Let's bring her out. Let's turn now to a sentencing hearing on Ms. Bell. Does the state have any evidence it wishes to offer in aggravation?
No, Your Honor.
Mr. Carter, or excuse me, Mr. Frost, do you have any evidence you wish to order in mitigation?
Judge, I would just like to state that Ms. Bell's crimes, as found by the jury to be guilty, were more of her being a willing victim, and that spilled over into what happened as to her children. It's terrible, and it's extremely sad that that happened, but I don't think that, and obviously she was not charged to the level that Mr. McNabb was, and I would just ask the court to take those factors. She didn't have the opportunity of having an upbringing, as I think I discussed in my closing. She had no role models for that. She was suffering from addiction and abuse, and should she have done something? Yes, she should have. She didn't, and that's what led her here. And but I think that there's through courses, coping mechanisms, things that she might learn through prison classes and afterwards, there would certainly be the possibility of her being someone who could be a productive member of society if she were to embrace some of those things and put them to use in her life. So we would ask the court to take those into consideration. Thank you.
Does your client wish to make any statements?
I didn't do this.
Stand up, stand up.
Y'all know I didn't do this.
Ms. Bell, you and I had a conversation
We did.
back in chambers on Wednesday, remember, morning? And at the time I told you there's a difference between the reality of the situation and what you think. I explained to you exactly why you were being charged with the crimes. It wasn't that you knew about the murder, it wasn't that you anticipated the murder, it wasn't that you planned the murder, any of those things. It was simply that you created an environment that caused your children to be put second and Mr. McNabb to be put first. As the state said in their closing, and they used the example of a rattlesnake being thrown into a room and the child being put into there. Well, your whole claim is I took him back because I wanted to have a family. In that analogy the state used, it's just kind of like saying your child's dead from a rattlesnake bite. Why would you put it in there? And you responded, well, I just wanted her to enjoy nature, have an appreciation of the outdoors, without appreciating the danger. Now, I'm sorry, but for you to go around chasing McNabb, doing meth, flies in the face of what any normal mother would do. We hear stories out in society, I mean, out everywhere. The mother bear, they're so ferocious. Why? Because you're messing with their child. All those kind of things. And you chose methamphetamine and McNabb over a baby.
It's a sickness, but I tried to be a good mama. I love my babies.
The problem, Miss McNabb, is that, like most criminals, you have this version of what a good mama is. that is so far from the norm that, you know, you go anywhere in this county, talk to anybody who's watching this and say, is it a good mama who doesn't even care about her 14-year-old baby? Put them with a cousin. I've known of instances where mamas won't even let in the first couple of weeks of a child's life people around the child for fear that the child's immune system hadn't been built up and they don't want germs brought into the child. They go to that extent. You went just the exact opposite direction. And there's just no excuse for that. On count, well, let's talk about this. Count 2 merges with count 1.
Yes, Judge.
What's the thought about count 3?
I think it's fine, Judge. It does not merge.
Okay. On count 1, I'm going to sentence you with 30 years, with the first 15 years to be served in confinement in the state penitentiary, the remaining time on probation. On count 3, I'm going to sentence you to 10 years in confinement and run at the same time as count 1. Now, do you understand your 2 sentences? Let the record reflect she's nodding her head slightly yes. And Ms. Bell, I'm going to give you the following rights that you have. Within 30 days, you have a right to appeal this case to the appellate level. You may start that process with a motion for new trial, which I'm going to direct the attorneys to file, just that skeleton general motion.
Yes, sir.
If at the time you decide, Ms. Bell, you can allege that your attorneys did an ineffective job. They just didn't do a good job. It has to be brought up at its earliest moment. The attorneys do not get their feelings hurt if you choose to do that. And we would appoint a conflict attorney to come in and take over the appeal. Do you understand me clearly about that? I need you to stand up first off. I need you to start verbalizing.
I understand.
Okay, because she's making a record on all this. It all has to be taken down. I'm also going to advise you that if the case is appealed to the appellate level and the appellate level affirms that case in the verdict and sends it back down for the service of the sentence, you have 4 years from the date it comes back down to file what is known as a writ of habeas corpus. That means I'm being illegally detained unconstitutionally, and I want my body out of jail. But it has to be done. It's a time-sensitive thing, and you only have 4 years to do that. You understand that clearly?
Yes, sir.
Now, do you have any other questions? Okay, take her on. Yes, ma'am.
Max on count 3 is 5 in confinement, Judge?
Is it 5?
Yes, sir.
Then it would be 5. But whatever the max sentence is, it'll be 5 years
concurrent.
confinement, concurrent. Okay, you may take her on back.